स्वतंत्रता किसे नहीं पसंद है? मुझे नहीं लगता है ऐसा कोई व्यक्ति है जिसे स्वतंत्र रहना नापसंद हो। It has been observed by the Supreme Court that unnecessary arrest is a draconian measure that restricts the liberty and should be used sparingly. In the words of the former Supreme Court Justice V.R. Krishna Iyer, quote, the basic rule may perhaps be tersely stated as bail and not jail, unquote. The Supreme Court and its judges have time and again they have made various observations, they have given suggestions, they have made certain remarks, they have issued directions and guidelines regarding the arrest and the grant of bail in the criminal justice system. And today in this video we are going to talk about the recent guidelines given by the Supreme Court on 11th July 2022 in Satendra Kumar Until versus CBI. The then Chief Justice of India, Mr. N.V. Raman, said that we have to do away with hasty, indiscriminate arrest and the difficulty in obtaining bail. Almost two-thirds of the prisoners in India are under trial, among which there are women, there are illiterate people who do not know the process. And even if they know the process, they do not understand the whole process of bail. In order to avoid all this, the Supreme Court has come down heavily on the police officers and given the recent guidelines. But before we look at those recent guidelines, we have to understand what is bail. Bail का मतलब होता है जमानत. Bail is the conditional temporary release of a defendant with a promise to appear in the court when required. जमानत उस जमानत उस संपत्ति को कहते हैं जो किसी अपराध के आरोपी व्यक्ति को जेल से छुड़ाने के लिए न्यायालय के समक्ष जमा की जाती है या फिर उस संपत्ति को देने की प्रतिज्ञा की जाती है. The Supreme Court observed that the guidelines would operate upon the satisfaction of two conditions. The first is that the accused was not arrested during the investigation, and second is that the accused cooperated throughout in the investigation, including appearing before the investigating officer whenever required. Secondly, the Supreme Court judgment has categorized offences into four categories. Category A offences are punishable with imprisonment of 7 years or less. Category B offences are punishable with death, imprisonment for life, or imprisonment for more than 7 years. Category C offences punishable under special acts containing stringent provisions for bail like NDPS Act, Section 37, Prevention of Money Laundering Act, Section 45, UAPA Companies Act, etc. And the last is Category D offences, economic offences which are not covered by the special acts. As regards Section 41 of CRPC, the Supreme Court has significantly observed that even for a cognizable offence, an arrest of the accused is not mandatory. Pertinently, Section 41 mandates the IO, that is the investigating officer, to record the reasons while choosing to arrest or not choosing to arrest. The Supreme Court relied on its judgment in Arnesh Kumar versus State of Bihar, according to which the police officer has to be satisfied that the arrest is necessary for one or more purposes which are given by in the subclauses A to E of Clause 1 of Section 41 CRPC. The Supreme Court, while laying down these guidelines on the grant of bail to an accused, has reiterated the aspect of personal liberty and constitutional guarantees available to an accused under the criminal jurisprudence. The court held that Section 41 and Section 41 capital A of CRPC, they are facets of Article 21 of the Constitution. Article 21 of the Constitution talks about the right to life and personal liberty. So the court held that these two sections, Section 41 and Section 41A, they are facets of Article 21 and that any arrest in non-compliance of these sections would entitle the accused to bail. The Supreme Court ensured that procedural safeguards are complied with and any non-compliance is sufficient to grant bail to the accused. Next is default bail under Section 167 Clause 2 CRPC. Supreme Court held that a failure by the investigating officer to complete the investigation within the prescribed time limit, that is 90 days, would actually enable the release of the accused and that such right is absolute and indefeasible. As regards Section 440 of CRPC, the court held that the conditions imposed for grant of bail, such as a bond, shall not be mechanical and uniform. Further, the Supreme Court observed that the High Courts must inquire into the conditions of the under trials who are not able to comply with the bail conditions, and that the mandate of Section 440 CRPC must be kept in mind while insisting upon the sureties for the grant of bail. The Supreme Court relied on its judgment in Husainara Khatun, where it held that the object of a bond is only to ensure that the under trial does not flee or hide from the trial. The Supreme Court reiterated the principle, which was given in Sunil Batra case, that bail is the rule and jail is the exception. The Supreme Court reiterated the principle that innocence of an accused is presumed, and it is on the prosecution to actually establish the guilt of an accused before the court. The Supreme Court further relied on its judgment in Nikesh Tarachand Shah and observed that a presumably innocent person must have his freedom to enable him to establish his innocence. The court also stressed on the need to protect constitutional liberties of citizens and reiterated this judgment in Arnab Manoranjan Goswami case, observing that criminal law must not become a weapon for the selective harassment of citizens. And lastly, the Supreme Court ultimately laid down the guidelines requiring bail applications to be disposed of within 2 weeks and for the anticipatory bail applications to be disposed of within 6 weeks. Thank you.